Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time to talk about all matters relating to the creation and administration of trusts and estates, the probate process, etc. So today I'm going to be talking specifically about the power relationships between the various parties who are involved in the really more so the administration of a trust or estate than the creation. So, when a trust is created, um, oftentimes the trustor or grantor or plurals of those, that is the people who are creating the trust, also act as the trustees. And so there's not a whole lot of change in how things are handled, especially if it's a case where, for example, it's a married couple and they're creating the trust to protect their assets, and they create what's called an inter vivos trust or a living trust. So this is typically revocable, and so they act as trustees, and really manage their own affairs as they did before the trust was created. So now that's obviously not always the case, but once once the grantor of a trust dies, now that trust needs to be administrated. And the same is true of an estate of property where there is no trust. Whether there is a will or not, that estate is going to have to go through the probate process. And so now the power relationships are going to change because the decedent is gone, and all that's left is hopefully from heaven, the decedent is looking down and saying, are my wishes going to be actually fulfilled, right? And so I'm going to talk about the various parties and their authority, and there is some confusion about this. I see this in my own practice where lawyers tell their clients things that are just not the case. And in so doing, they cause dissension, they cause confusion, they cause extra expense to the estate, to its detriment. So first off, is the party who is going to be the administrator, and I use that term broadly now. So in the case of a probate, meaning there's a will or the person died intestate, so either the will appoints an executor, okay, and I've mentioned this term many times in the past, or an executrix if it's a female, although you don't really hear those gender-specific terms used anymore. Or if there is no will, so the court will appoint an administrator, and that in all cases, that person, not in all cases, but I say in many cases, that person is known as the personal representative of the estate. So while some jurisdictions use one term or another, in general, personal representative encompasses an executor or an administrator, for that matter, a special administrator. And so I'm going to, in general, use that term. I'm also going to use that term when I mean a trustee, even though technically a personal representative is court appointed and a trustee is appointed by the document that created the trust. So and just so I'm not constantly going personal representative or trustee or administrator or trustee, just to simplify the language. So again, I'm going to use this term personal representative, meaning broadly the person who is administrating the assets of an estate, whether they're in a trust or not. So the personal administrator has typically very broad authority. So sometimes they will have authority over all the assets of the estate. Sometimes and in this case, I'm speaking about a court-appointed personal representative. Sometimes they will have authority over only some of the assets of the estate. For example, all of the assets except real estate. Now, part of that has to do with um, what what the court decides is appropriate for the administration of an estate. It also has to do with whether the whether the personal representative needs to have a bond, which in most cases he will. And so, if you're talking about the management of let's say $100 million estate, where $80 million of that estate is real estate, so what the court may do is give the personal representative authority over everything but the real estate, and therefore they only have to post a $20 million bond, which that alone could easily cost $20,000, the premium on that bond for a year. But if they gave the personal representative authority over all the property, including the real estate, so now you're talking about $100 million estate, the premium for that bond could easily be $100,000. So again, it just depends, and it's certainly within the personal representative's authority to apply to the court for broader or narrower authority based on what the personal representative thinks will work the best for the particular situation. Now, a trustee will typically have very broad authority, will have authority over all the assets of the trust, and oftentimes the terms of the trust will waive the requirement for a bond. So it's assumed that after, again, assuming it's a case where the trustors were the trustee and now they're deceased, and so a successor trustee has stepped up to administrate the trust. So generally it's assumed that that person, having been selected to be the successor trustee by the trustors, the grantors, so that person is trustworthy enough not to require a bond. Also, typically the trustors don't want to burden the estate with the cost of a bond, and so there will be a waiver of bond as a term of the trust. Okay. But a trust too, by the way, can limit the authority of the trustee. Again, typically it will not. Typically there will be a recital, or I shouldn't say a recital because that has a specific legal definition, but there will be a list of authorities that the trustee has, and typically they're broader than what the trustee would need in order to administrate the assets of the trust. Okay, but again, I've been in situations where it seemed like I needed every single authority that was given to me as trustee because of the various problems that arose in dealing with the various assets and the various situations. And so that's why these trusts tend to write the authority of the trustees very, very broadly to make sure that they can, as efficiently as possible, fulfill their duties. Okay, so in general, those duties are collect the assets, identify the debts, pay the debts, and then distribute the remaining assets to the beneficiaries. Okay, and that's true of both a probate and a trust. That's essentially what the they have power. The personal representative has power to do. Okay, now within that, there can be a lot of nuances. So let's say, for example, the estate owns a business or the trust owns a business. Well, so the personal representative is going to most likely have the authority to run that business or hire people to run that business, depending on whether the personal representative has the experience in that particular business. Okay, so if you've got a personal representative like me whose background is real estate, and there's a business owned by the estate. It's I don't know, it's a trying to think of a business I don't have any experience running at this point in my life. It's a medical business. Okay. So the trustee might not run that business directly, but might bring someone in to run the business if the decedent was the person running the business. Now, if the decedent was already out of the business but still owned it, so then most likely the trustee will just oversee the people running the business to make sure everything is going smoothly and operating, and the business is maintaining its value, and kind of dos vidania, as we say, just let things go from there. Now, when it comes to relationships, this is one of the things that is, I think, oftentimes misunderstood. So when an estate is in probate or is still held by a trust, okay, it is not owned by the beneficiaries. Okay, they are not the legal owners. The trust or the estate is the legal owner of those assets. So the beneficiaries stand to benefit from that, and I'll talk about beneficiaries in a few minutes. But they do not own any of that property, and they do not have decision-making authority over it. In fact, the personal representative has sole decision-making authority, especially if the personal representative is a trustee. And if the personal representative is an administrator in a probate, then that authority is subject to oversight by the probate court. Okay, so talking about a trust again for a minute, trusts oftentimes will even have a provision that says if the beneficiaries challenge the trustee's actions, they can be disinherited. Okay, I have a situation like that I'm dealing with right now. And so the idea is to give the trustee not just the broadest power, but also the power relationship. Okay, so although a trustee must administrate a trust for the benefit of the beneficiaries, okay, it is oftentimes in the trustee's sole discretion to determine what that means. Okay, and the beneficiaries have only very, very limited ability to have any impact on that. Okay, now the same is generally true in a probate. So the personal representative, it's really in the personal representative's discretion to make decisions about the administration of an estate. Now, there typically will be a lawyer involved, but the lawyer actually represents the personal representative, not vice versa. Okay, so again, although the lawyer will give advice and the lawyer will talk about the legal issues and consequences of particular decisions, the lawyer does not have the authority to make the decisions. We'll talk about that more later. So the only check and balance on a personal representative in a probate is the court itself. Okay, and again, we'll talk about the court as well. So if the beneficiaries in a probate, or to a probate, I should say, beneficiaries to an estate that's in probate, think that the executor, the personal representative, is misadministrating the estate, they have the authority to apply to the court, essentially to have that personal representative removed. But that's really the only authority that they have. Okay, they don't have authority over individual decisions. And likewise, in a trust, the beneficiaries may have the ability to challenge the trustee's decisions, although oftentimes not. But as a last resort, they can go to court and ask that the court remove the trustee and replace the trustee with somebody else. Okay, how all that plays out is a very individual issue. Okay, but that's in terms of day-to-day administration of the trust, beneficiaries have no say. Now, one more thing about these power relationships. A smart personal representative will communicate with the beneficiaries and understand what their um, wants and needs are, and potentially take them into account to the extent that they conform to a proper administration of the estate. Same is true with a trust. So an intelligent trustee will communicate with the beneficiaries, understand their point of view, and to the extent that what the trustees want also conforms to the best interests of the administration of the trust, or I should say the proper administration of the trust. So then there's no point in causing needless conflict, just to do something different than what the beneficiaries want. Okay, so it's not that the personal representative is prohibited from communicating with the beneficiaries or soliciting their thoughts, their, like I said, their wants, their desires. That would be best practice to do so. It's just that when it comes to out and out power, the power rests with the personal representative, not the beneficiaries. Okay, now I've been talking a lot about beneficiaries, so I'm gonna address them next, which is, so the beneficiaries are the individuals or entities, organizations that are going to benefit from, receive the remaining assets from the estate or trust. Okay, that is the assets left after debts have been paid. Okay, now they have as I've been saying, they have little direct power on the administration of the estate or trust. Okay, they hopefully, the personal representative is knowledgeable, knows what he's doing, and recognizes that it's in everyone's best interest for him to be in regular communication with the beneficiaries and to solicit their input. Okay, that goes a long way toward avoiding disputes, and disputes that can be very hard emotionally as well as financially on the administration of the estate. Okay, so the beneficiaries may have influence, but not power. Okay, so they can't dictate, but they can express their point of view. They can discuss things with the trustee, or with the personal representative. And now, if you are a beneficiary, or if you end up being a beneficiary, I would recommend, number one, that you seek to establish a good communicative relationship with the personal representative, a cordial, mutually respectful relationship. Okay, and it's in your best interest to work to do that as well. So if you're inordinately demanding, if you make unreasonable requests, okay, that's not going to help you out, either in the short run or most likely in the long run. Okay, especially if the personal representative starts to think that you're looking to ride roughshod over him and usurp his authority, and especially if he thinks you're putting him in a situation where he could be breaching his fiduciary duty. Okay, so understand that a personal representative, whether it's in a probate or in the administration of a trust, acts in a fiduciary capacity. So unless you have grounds to submit to the court that fiduciary duty has been breached, it is unlikely that um, that applying to the court for removal of the personal representative is going to be successful. The fact that the personal representative will not do what the beneficiary requests or demands does not constitute a breach of fiduciary duty. Okay, it merely it could merely be just a difference of opinion, and especially if the personal representative is very knowledgeable about financial matters and the beneficiaries are not, it's likely going to be assumed, or not assumed, but the court is likely to decide that in fact the personal representative is handling things properly and discount the beneficiaries complaints. Okay, so when we talk about the power that a beneficiary has, that power really comes down to being able to go to court to have the personal representative replaced. And again, it's most likely to happen only in a situation where there's hard evidence that the trustee has breached his fiduciary duty. Okay, beyond that, influence, but no power. Okay, and this is this is really the crux of the matter. And so I stress again that it is in the best interests of all parties to maintain cordial cooperative relations. This is true between the personal representative and the beneficiaries, and it's true between beneficiaries as well. So if beneficiaries start fighting over who's entitled to what, and they start challenging each other's rights in court, and the personal representative's authority to act as a sort of referee between the various beneficiaries, typically that ends up being extremely costly, and the people who lose out in the end are the beneficiaries themselves. Because keep in mind, the assets of the estate go to the beneficiary. So the more of the assets that have to be spent on court activities, legal costs for lawyers, costs for filing of documents, payment to the personal representative, payment to experts, whether they're appraisers or accountants or whatever, all of that reduces the assets that are available for the beneficiaries to receive through the trust or at the closing of the probate. Okay, all right, so that's the beneficiary. That's their role, and again, limited power. Okay, next are creditors. So as the term states, creditors are people to whom the estate or the trust owns money. Now, not all people who claim to be creditors are necessarily bona fide creditors. So in a probate, there is a period of time specified by the probate code for each state during which creditors have to be notified that a decedent has died and the estate is now in probate, and when those creditor claims have to be filed. Okay, so here in California, I believe it's 90 days if memory serves. Okay, once 90 days after notification has passed, I'm just using 90 days as an example. It can vary from state to state. But once the period post notification for creditor claims to be filed has passed, okay, those creditor claims may not be recognized, and in fact, the personal representative may not be able to pay them. It could be a breach of his fiduciary duty to pay a creditor claim that was not filed on a timely basis. Okay, and again, this is where some disputes can rise. So let's say that death of a decedent was given today, which is September 30th. Okay, and the law requires that that the creditors have 90 days to file a claim. So that would basically be until the end of the calendar year. Okay, so and let's say a creditor didn't file a claim until mid-January, that somehow they, I don't know, it fell through the cracks, or they just didn't get their act together, or whatever happened. Okay, so it may very well be that the personal representative can no longer pay that that debt. Now, the creditor may turn around and claim, well, I didn't get notice on September 30th, even though that's what the personal representative is claiming. And so therefore the window isn't closed, and therefore this is a valid claim. So again, this is most likely going to be an issue to be resolved by the court. And so now there's going to be lawyers and the personal representative's time, et cetera, et cetera. Okay. So if you are a creditor to an estate, be aware that there are deadlines for filing your claim, and be on top of those deadlines. Okay. So if the proper procedures have been followed by the personal representative and the lawyer that's assisting him, the court can, definitely prevent the payment of the claim. And in fact, this could be a situation where the beneficiaries, if the claim was paid wrongly by the personal representative, the beneficiaries could claim, indeed, that was a breach of fiduciary duty, and have the personal representative removed, because now assets have been wrongly paid out of the estate, and so the beneficiaries are losing out, and so now there'll have to be an action to reclaim those assets from the creditor, et cetera, et cetera. Okay, now, so creditors generally have power just to the extent that they have a properly filed claim on the estate. Okay, beyond that, they don't have a whole lot of power. Okay, now, assuming they have properly filed their claims, so then they're going to have the court to back them up in getting paid, in getting that claim paid. And so the court, part of the court's responsibility is to see that just debts are paid. Okay, but that's not power in the hands of the creditor per se. That power is actually in the hands of the court. That's why it's so important to have creditor claims timely filed. Now, if a creditor has a claim against a trust, so that claim is going to be handled by the trustee according to the terms of the trust. Now, in many cases, first of all, there's no creditor claims process in the administration of a trust, because oftentimes, let's say there's a loan on a property. Okay, so oftentimes that loan is going to survive the administration of the trust, and it's going to continue to be a debt against the property when that property is distributed to the beneficiaries. Again, it depends. All of these situations have their own sort of unique parts, and so it really just depends. But in general, the administration of creditors in a trust is much simpler than it is in a probate. So there's typically not a period during which claims have to be filed, that sort of thing. Okay, now let's say that a trust has a debt that has a clause in it that says it can be called on death of the trustor. Well, so in that case, then, the trust is going to have to pay that debt. Okay, I'm sorry, the trustee is going to have to see to it that debt is paid by the assets of the trust. So that's where, there's as many different situations as there are trusts and lenders and trustors, et cetera. So, but in general, because a trust is not subject to court oversight, so these things can be handled more easily. Okay, so that's creditors. Again, they don't have a whole lot of power, but they do have the ability to make a valid claim against an estate, and then the court will see to it that it's paid. Okay, next are attorneys and or estate planners. Really, estate planners have no authority at all in the administration of an estate. They may be called upon for clarification of something, but they have typically no standing in the court. They have no standing in a trust. They were an advisor that helped the decedent or the trustor set up their, how their estate was going to be handled at their death, but they don't have any power at all. Now, attorneys, as I mentioned earlier, they are in an advisory capacity. So again, they do not have the authority to make decisions about the administration of the estate or trust. They are there to, in the case of a probate, represent the personal representative in terms of legal matters and provide legal advice. And in the case of a trust, they're also there just to see to it that the trustee is complying with the terms of the trust and not violating his fiduciary obligation. In the case of a trust, a lawyer has no obligation to report anything to a court. Again, their duty, they are actually the trustee's lawyer. Okay, they're not the trust's lawyer. Okay, they're advising the trustee, and their duty is to the trustee, generally speaking. Now, a smart personal representative will listen to the advice of his lawyer, and especially if they're not particularly experienced, in many cases, follow the advice of the lawyer, especially if the lawyer is much more experienced than they are. And if you are an inexperienced personal representative, you are well advised to make sure that the lawyer that you use is very experienced, because there can be a lot of nuances about how things happen, about how things should be done. And that lawyer can, number one, keep you out of trouble, and number two, help you save the estate or the trust a lot of money by showing you the path for getting certain things handled in the most efficient way. So, not unlike the beneficiaries, okay, the lawyer has the ability to give advice. Again, a smart personal representative will consult with the lawyer on a regular basis, have a good working relationship with the lawyer, but the lawyer does not have any power to make decisions, nor does the lawyer have the power to challenge the personal representative's decision in court, because the lawyer represents the personal representative. Now, beneficiaries sometimes will hire their own lawyers, okay? And just like it's a good idea for the personal representative to have a good, cordial working relationship with the beneficiaries and with his own lawyer, if other lawyers get involved representing the beneficiary, at that point, the personal representative's lawyer should create a good working relationship with the beneficiary's lawyers, because the beneficiary's lawyers can advise the beneficiaries to challenge the conduct of the personal representative in court, whether it's an administrator in an estate, or whether it's the trustee in a trust. Okay, so again, the beneficiaries' lawyers, they themselves do not have standing to challenge what the personal representative is doing, but they can advise the beneficiaries to take action, and in so doing have a lot of influence as to whether that happens. And so their power, I use that term loosely now, comes from the influence, the amount of trust that the beneficiaries may have in them. And also, they will have some indirect influence on the personal representative, to the extent that they are able to convince the personal representative's lawyer that they have good arguments, or they have facts to support what it is they're asking to have happen, etc. Okay, so these are these are the interplay of the various relationships of a trust. I mean, of the administration of an estate or the administration of a trust. And it's always best for people to work things out cordially if possible. But that doesn't, you know, um, but that, unfortunately, that doesn't always work. That's kind of the bottom line. But that should be the goal. Okay. So again, attorneys have influence, but they have no real power in the situation. So the other party, if you will, not really a party per se, but the other party, I'll use the term loosely, that has a lot of power in the administration of an estate, though typically not a trust, is the probate court. Now, we speak of the probate court as a place, but the probate court really comes down to the judge. And it can be, how the power of the probate court gets wielded will depend largely on the judge, but also, and this is very important, it will depend on the court's clerk and the probate attorneys who work for the probate court who are advising the judge. Okay, so while we tend to think of the court as being the judge, there are other individuals within the probate court who actually can wield a considerable amount of authority, even though technically it's not theirs. They're wielding it on behalf of the judge, or because of the way it can influence the judge. Okay, so let's talk about for a moment the role of the court. The role of the court in the administration of an estate. And again, this doesn't apply to a trust. The purpose of the trust is to avoid probate court. So the role of the court is to oversee the administration of the estate and make sure that it's conducted in accordance with probate law in the particular state in which the probate is taking place. Okay, so essentially they have oversight of the personal representative. And depending on what needs to be done to administrate that estate, the personal representative will, not periodically, from time to time, petition the court for approval of certain actions, or for a certain authority to do a certain thing, or for distribution of a property, either an interim distribution or distribution of the assets when the probate closes, etc. Okay. Now, the court is supposed to be a neutral party in the administration of the estate, meaning the court shouldn't be favoring either the personal representative or any of the lawyers or the beneficiaries, right? The court is supposed to be neutrally applying the law. Ha ha, right? I mean, we want to think of courts as neutral, but oftentimes courts have their own agenda. And so I can tell you again from personal experience, the idea that the court is there to facilitate the administration of the estate, so as little money as possible is used in the administration, is clearly not true. So I've been in situations where it appeared that the judge's sole goal was to clear his calendar. Okay, so I recently had a situation where there were 31 cases on the judge's docket, and of those, only 4 or 5, I think it was, actually made any progress, and the rest were postponed for 1, 2, 3, almost 4 months. Okay, in order to just get through the cases as quickly as possible. All right, that was clearly the goal of the judge. Now, you could say, well, 31 cases, that sounds like a lot. And indeed, it was a lot. Okay. The fact of the matter is, this particular court is understaffed based on what I've seen, and so judges are trying to handle too many cases. Okay. Now, if you ask me, the proper way for that to be handled is for the judges to say to the presiding judge, "Look, there's not enough of us to properly handle these things. We are costing estates a lot of money by continuing, in other words, putting off to a later date the resolution of matters or the hearing of matters, etc. Because I can only hear a lawyer for 2 or 3 minutes give thoughts on what ought to be done, and that's not good for the system. But that is how this particular court works. However, having said that, some judges do not have what I would call sufficient humility in the exercise of their authority. So I'm talking about another matter. The judge is young, and I think she really likes being able to wield her authority against lawyers who are significantly older than she is. So, it's unfortunate, and it shouldn't happen that way, but that just is how it happens. And it's a reality of the probate court. Now, what can be done about it? Well, complaints can be leveled against judges. There are, boards that oversee their conduct. If something a judge does is particularly egregious, the decision can be appealed, although that is costly. Okay. And so in the end result, the judge is very, very powerful. And there's another factor that goes into the power that the court has, and that is the attorney who is advising the personal representative oftentimes is handling matters knowing that he may have to handle another matter in front of the same judge down the road. And so he doesn't want to get on that judge's bad side. Okay, so you may have a personal representative who this is the only estate that personal representative will ever handle. Whether the judge likes the personal representative or not is immaterial to the personal representative. Okay, nonetheless, the lawyer may be counseling moderation because he's concerned that if he really gets the judge mad, that in a future matter there will be more difficulties in administering that one because the judge doesn't like him. Now you could say, well, wait a minute, the judge is supposed to be neutral. I thought you just said that. Of course, but judges are human beings. They have their things, if you will, and it can be very, very difficult to prove that in fact a judge is acting with animus toward a particular party, a particular lawyer. And so all that's happening is, for some reason, your decisions on your probate keep getting put off, and it keeps going on and on and on, and you're not able to make practice. Or you're not able to make progress. But you can't tie it directly to animus on the part of the judge. So that's just a difficulty. And it's another factor that sort of enhances the power of judges is the same lawyers practice in front of them on a regular basis in many cases. Now, I talked about other parties that have authority, and I use that term in that case somewhat loosely because, again, their authority comes from the judge. So the clerk of the court can have a lot of authority in certain cases. So if they don't think that a case is ready to be heard for some reason, they can have the case continued. Okay. And again, you have the same dynamic with the judge that you do with the clerk. So attorneys oftentimes are reluctant to get a clerk angry at them because they may have to have another matter heard in the same court where that clerk is the clerk, and now the clerk may bear them animus, and it could be detrimental to that next case. So oftentimes the lawyers will go along with what the clerk is doing, even if it's somewhat or even very unreasonable, in order not to create problems down the road. And clerks know this. And so some clerks will take advantage of it, even though their judge may not strictly agree with what the clerk is doing. So if the clerk has a good relationship with his judge, and the judge is very likely to defer to the clerk's judgment, so then the clerk is going to wield quite a bit of authority, even though it's not really the clerk's authority, it's the judge's authority. Now, I mentioned this other party in or other sort of aspect of the probate court. It's called a probate attorney. Now, we talk about the category of probate attorneys. Oftentimes, what we mean are attorneys who are representing personal representatives. But I know here in the courts in California, we have probate attorneys who work for the court. And what they do is they review cases for upcoming hearings and advise the judge on whether all the documents have been filed, whether there's anything missing, and how the law may apply. And in many cases, they will make a recommendation about what the judge should do. Now, it's an interesting dynamic, because the probate attorneys who work for the court, they do not have the power to make a decision. So they don't have any real authority. Their authority, in the same way as the clerk, comes from the relationship they may have with the judge and how willing the judge is to agree to the probate attorneys. They're called PAs for short, the PA's recommendation. Now, just like with an inexperienced personal representative, they should have an experienced attorney advising them to help them do the most efficient job, the best job administering the estate. You would think that a judge who's relatively new to the bench would want a PA who's very experienced and would give very serious thought to following that PA's recommendation. This is where judicial humility is an important aspect of a judge's character. So again, from my own experience, I've got a case with a judge who's relatively new to the bench, and we had a petition heard in front of her, and her PA recommended that the petition be granted, and she ended up being undecided on it. That was the best we could do. She was inclined to deny it, and in the end, we convinced her that she should actually read the file, which she hadn't done, prior to the hearing, which is a whole separate issue. Okay, so these are some of the problems with the probate process, and in fact, I've got a show that that's scheduled upcoming to talk about some of the problems in how the probate system works. But in any event, the PAs, the probate attorneys who work for the courts, again, they don't actually have power. Whatever authority they have really comes from the degree of influence they have over the judges for whom they work. Okay, but in the end, the court, in the case of a probate, pretty much has the ultimate power, because they can overrule things that the personal representative wants to do, or can overrule something that the personal representative has done, and can even remove the personal representative from that role. Okay, and so the reason is the probate court is there to protect the interests of the creditors and the beneficiaries, to see that they're not cheated, in essence. Okay, so the two real power players, if you will, in the administration of an estate are the personal representative, be it an administrator or a trustee, and the court. Okay, that's where the things it essentially get worked out. Well, I should say, I'm sorry. Let me rephrase that. Between the personal representative in a probate and the court. Okay, that's where the power lies. In a trust, the power lies with the trustee. Okay, beyond that, the beneficiaries and their lawyers through them they have the ability to challenge decisions made by either an administrator or a trustee in court, although typically those challenges have to be a breach of fiduciary duty because the personal representative acts in a fiduciary capacity. That's why here in California we have a professional fiduciaries license that people who, like me, who routinely administrate estates, we have to have that license. Okay, and beyond that, creditors have the power to timely file claims in a probate. Beyond that, not a whole lot of authority. Okay, so that's how the power relationships play out, and it's important to recognize these. So I mentioned at the beginning, oftentimes, not oftentimes, but sometimes a misunderstanding of these power relationships cause problems. So I have a situation where a lawyer has told a beneficiary that in the end, he has the authority to make decisions. That's not true. Okay. That's not true. In this particular case, I confer with the beneficiary on a regular basis, and I work to take his wishes into account, but he does not make the decisions, nor does he have the power to make the decisions. I do. And that's as it needs to be, because in the end, I have sole responsibility for those decisions. So if I make a decision that turns out wrong, I can't say to the court, well, I was just doing what the beneficiary wanted me to do, because the court's answer will be, well, that was stupid of you, because the beneficiary has no authority to make decisions. So you can't blame a bad decision on the beneficiary because you're the one who has the authority. Okay, or you're the one who has the power. All right, so it's very important to understand these power relationships. Hopefully this has given you some clarity, some insight into that, and will help you in the administration of an estate or trust, help it go much more smoothly. So thanks so much for joining me today. And let's see, tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. And my topic is, I don't remember. Okay. Oh, so my topic is adapting to change. I'm going to be talking about General John Pershing and how he handled his fighting during the border war against Pancho Villa versus what he did in World War I, and to talk about this idea of adapting to change. And then on Wednesday at 10 a.m., I'm going to be, for my show, People Making Money. By the way, these are all Pacific time. I'm going to be talking about building routines for success. So I'm going to be talking about a book called The Power of Habit by Charles Duhigg, one of my favorite books. It's an absolutely outstanding book, and it really points the way to how we can build what I'm calling routines for success. And then 7 days from today, I'll be back at 10 a.m. Pacific time for the next edition of Trust and Estates Weekly. So once again, I thank you for joining me today. Wishing you a wonderful rest of the day, and signing off as I always do, Marie, darling, you are my belle.